Welcome to Just Verdicts with your host, Brendan Lupetin, a podcast dedicated to the pursuit of just verdicts for just cases. Join us for in-depth interviews and discussions of cutting-edge trial strategies that will give you the keys to conquering the courtroom. Produced and powered by LawPods.
All right, Just Verdicts, another episode, and here we're talking today with Dan Purtell, managing partner of McEldrew Purtell. So, Dan, thanks for joining us today. As you and I were just talking about, it's cool to have you on the show because just the way life works, sometimes you interact with an attorney many years ago on a totally irrelevant matter, and then come full circle and bump into each other on a podcast. And I was thinking about how, that was probably 7, 8, 9 years ago that we both had those Olympus duodenoscope cases, and I think we were sharing some info and so forth on that.
Yep, I remember those cases. They almost broke me with 100,000 pages of documents before we had e-discovery technology.
Yeah, we co-counseled with Panish's firm out in California on a few of ours and let them do the heavy lifting on the documents. So I wasn't as much of a broken man at that point. But it's great to have you here. And what I'm interested in is I want to start a couple different things. So, traditionally it's just verdicts. We just talk about verdicts, but your firm growth and how your firm has expanded and the results that you guys have been getting as of late is really interesting to me. I think it's pretty interesting probably to a lot of other attorneys out there from smaller firms looking to grow and so forth. So obviously, personal injury firm, I know you guys do medical malpractice and a variety of other cases, but can you walk me through, let's say, the last 5 years, the evolution of your firm and how you're looking at it from a strategy perspective, a growth perspective, breaking people out into different teams, focusing on, going deeper rather than wider on cases and the kind of results you've seen that generating for you.
Of course. First of all, thanks for having me. I appreciate the invite. McEldrew Purtell, it was started and founded by Jim McEldrew and has several iterations over the past 30 years. His practice was primarily a general injury, FELA railroad, and then, select med mal cases. I think if you're talking about pre-COVID, we were probably 10 people. Today, we have 15 lawyers. We're looking at having 50 team members by the end of the summer. You mentioned team-based. We're broken into 6 or 7 specialized or focus teams with a group on med mal, group on nursing, civil rights, still with FELA, which is a big centerpiece of our practice, trucking and workplace, toxic torts and products, and then we have 2 separate what we call catastrophic teams that are led by myself and John Coyle, and we, across any of those practices, if there's a special case, let's call it, or a case that we see some real high-end value in it, we bring that into the catastrophic team, and it gets more love, more attention, more resources, deeper work, as you mentioned. So, what our focus over the past several years, starting with the challenges of COVID, has been to completely overhaul our operations. As many people in this industry know, law firms aren't always run like a traditional business or like a business at all in some circumstances, right? So, Jim did great work for a long time, but it was definitely an old school mentality. And we've really done everything under the sun that we can think of to modernize our practice, whether it be finances, whether it be technology, whether it be a hybrid work environment where people are working from home. We really try to lean into anything that makes us better, and I think we've done a pretty good job so far.
What was the impetus to dividing lawyers up into more focused groups of practice areas?
Really, our focus is on larger cases. Everybody has their own business model. Everybody has what they think that they are focusing on, what they're good at. I found that we were not good at doing volume of repetitive work. We just didn't have good results. we were not meant for that. That said, when we had bigger cases, we were doing great stuff. Everybody was intrigued, or I should say, invested and involved. And we have people that have real dedicated backgrounds, experience, interests in some niche practices. So when we find someone with that talent, we're pretty adept at generating business. So when we find somebody who really wants to lean into med mal, we kind of focus on generating some med mal. If we find when we add a teammate that has a background in a dedicated experience set in toxic tort and practice, then toxic tort and products, that is, then we lean in on toxic tort and products. So we've been successful at developing niche products or niche practices over time, and we're seeing really good results from it.
On the front end, from the perspective of getting those big cases, are you guys predominantly referral, or are you actively marketing for cases, or is it a combined approach?
Combined, leaning heavily to referral. We are when it comes to that caliber of cases, we are highly referral based, upwards of 85-90%. There are some passive cases that come in through recommendations of old clients. We don't do much marketing. We're starting to delve into some e-commerce tactics, looking at and trying to find ways to target high-end cases. But again, our real focus is the partnerships that we've been able to form and foster over years with people that are marketing themselves. So we kind of stay out of their lane in large part, and let the people who specialize in marketing market, and we hope to provide the best referral partner option there for them when they get a case that's slightly out of their wheelhouse.
Dan, what's your advice to firms, say like mine, because I'm a much smaller operation than what you have grown to, and we are predominantly referral based as well. And as the owner of the firm, there's always that concern of, from if you have a really well developed, paid marketing campaign, at least so it would seem, there's more predictability versus, well, how do we know that people are going to refer us these cases that are going to serve as the lifeblood of the firm? Where do you get the confidence to know that, that stream of these, solid referral cases are going to keep coming into you guys?
Really, it did take, well, one, we were relatively unsuccessful in several attempts at trying to be both lawyers and dip our toe into marketing, realizing that we're certainly good at what we do, and we're not necessarily don't have enough bandwidth to become great at other things that are slightly outside of what we do. So, marketing was not, I didn't see a path for us to really compete at a high level in the marketing space without being led around by, consultants and external third parties that we don't speak the same language anyway. So, we really made a commitment to sticking with what we do best. And yeah, it is, specifically when you make that decision to start turning down lower value, what might not be the high value cases, from a source that has been, a good relationship for a long time. The real apprehension is if I say no to a case, are they going to come back? Right. And I think that the way that we choose to handle that is to be open and transparent from the beginning. Right. We try to the extent that a case isn't for us, we try to make connections with other lawyers that might be perfect for the case. Right. I am a believer that there's a lawyer for every case, and they're the right lawyer. And if it's not the right case for our firm, we're actually doing the client a disservice, because if it's not going to be, a priority on our attorneys' boards, then the case is not going to get the attention that it deserves. Right. Because every case deserves to be a priority of the attorney handling it. So I think it's just being, consistent, making that hard first decision that can be scary, right? Saying, I'm not going to take these cases. We're going to pass them off to somebody else. And, there is that fear that you're not only losing that case, but you're jeopardizing the source. But what we've seen, if you manage the discussion, if you're open and candid, if you help, even if you're not going to be on the file, and do your best to make sure that referral source and that case get to where they need to be, that it works out. And at the
Yeah,
end
I
of the
think
day, at the end of the day, producing results on the files that you do keep, I think, is really where the rubber meets the road, right? That is what keeps people making the phone calls. I feel, right? Especially
yeah,
recently, we've had a decent amount of success.
yeah, I think if obviously you get the great results, and the referring attorneys obviously are rewarded by how well you do for the cases they send, combined with the fact that you're, for lack of a better term, branding yourself as, hey, we only handle the really high end catastrophic cases. We really appreciate you sending this one over. It doesn't quite meet our criteria, but we've got a great attorney to send you to. You nevertheless are still developing the fact that your brand is, oh, the big case goes over to Dan's firm. And if not, Dan's got the answers of who I can send these other cases to. And hopefully those firms you're sending to get great results on the smaller cases.
Exactly, and it's taking that, it's setting that line, being consistent, and you just hit on something. It's a two-way relationship that you get to foster there. Not only are you helping out your referral source, but you get to help out a friend who has a practice that's perfect for the case. And so you're really, and by doing that, yeah, you're setting in both of, making the understanding that the cases that you're looking for clear in both of those parties' minds, so that next time something crosses their desks, hopefully maybe you get thought of, and the case comes to you. So and you're helping out two different people who would become friends. So it's a good practice.
Tell me more about the impetus for becoming more of a, running the firm more as a business rather than, sort of the traditional law firm type practice. Like, what was it that really made you the light bulb go off to say, look, we've got to be more intentional about running this like a business? And if you could weave in the fact that I saw on your website that you guys have a COO, and how that all fits together.
Yeah, I would say working 100-hour weeks for the better part of a decade, doing everything under the sun, and a combination of realizing that, the case that you get stuck in takes more time than the case that you can't wait to work on. Right. So those two kind of combined realizations. When we were a smaller firm, I mean, God bless the people that are with us from that time, because it was a chaotic, it was really a jack of all trades, master of none environment, where everybody was kind of just doing what needed to be done in real time to triage situations and to get us through whatever was going on that day. So the lack of continuity in the non-legal specialties or the non-legal needs was, I mean, apparent on a daily basis. And certainly not in my skill set or background or interests for that matter. So really learning, I mean, I've learned a ton from podcasts. I think that, you're doing a great thing. To the extent there is a golden age of legal podcast, I think we're in it, at least the first iteration. I've learned so much from other people that have done podcasts, and I remember one saying you got to let go to grow, right? So taking that step to trusting people to do distinct defined roles. And so over time, that's really taken on a whole new meaning for us. We went from pretty much being all revenue oriented, right? Like every task was focused on producing revenue as opposed to non-revenue generated roles, not realizing or not really paying attention to the fact that when we got pulled away to do other stuff, it took us away from generating revenue, us being the lawyers. So really kind of having that epiphany that to the extent that we're able to build accountable teams in the non-traditional legal operations of the firm, that the lawyers get to do more lawyering and get to do it better and get to do it more aggressively and get to do it faster. So you're getting better results, you're maximizing numbers faster, makes everybody happier. So it's really an attempt to be better at casework, right? By finding other people that are better at operations, that are better at accounting, that are better at marketing, that are better at people, right? So there's any number of non-legal professional disciplines that go into operating a modern law firm, and specifically with the numbers we're getting to, it's just a whole different animal now. So yeah,
Have you
we're relying heavily on professionals that are from outside the legal space.
so have you because obviously, yeah, I mean that's one of the biggest headaches that you know I face as the owner of this firm with my partner Greg is, having to do those aspects of running a firm that are not just what I mostly love to do, which is be a lawyer, dig deep in cases, work them up, do focus groups, try cases, and so forth. So, have you? And I guess if you could even go a little bit deeper on, how have you delegated a lot of what was taking you away from where you add the most value to other people that, they add value in that to the firm so you can do more of what you do?
Well, just for my team, in case they're listening, I know I need to keep doing a better job at it, right? Staying out,
Always, right.
because it's still not a natural thing to delegate as much as you really need to. And specifically coming from where we're used to having our hands on everything, it's hard to delegate in that capacity. Um, but once you see the benefit of it, like I echo your sentiment. I still love doing cases. I truly do. There are cases that I think about all the time. I truly enjoy it. I say like that I'm meant to be this type of trial lawyer. I got fortunate in that capacity that I happened to find the career that was right for me. But I'm certainly not a great manager all the time or much of the time, right? Maybe I'm not the best at leading teams that I don't understand. Maybe I think I understand more of technical aspects outside the law than I actually do. And so really getting to a point, and I'm still working on it, to be able to trust other people to handle and truly be accountable for those roles, really gives me a chance to do what I love to do more. So at the end of the day, it's, when I think about it, might be a little bit of a selfish um, initiative, right? Because I get to focus on what I want to be doing. And overall, I think our firm is better for it because I'm not messing things up in other spaces.
Compared to say where you were, pre-pandemic, how much, non, we'll call it trial work, or, working actually, being in there, being the trial technician, the case technician, percentage wise, how much have you been able to get yourself into that role compared to also trying to be manager, marketer, rainmaker and all that different stuff, over that period of time?
I'm still very much in both spaces, right? I'm very fortunate to have fantastic teammates and lawyers on our team. John Coyle, Danielle Duffy, Colin Haviland, Mark Washington, Ian Norris, Andy Watto, Mark McGuire. I mean, they're all brilliant. I'm sure I left a couple out. I apologize, but they're all fantastic, top of the pyramid lawyers in what they do, and so I'm blessed to be able to practice with them. So I have a lot of support on the cases that we do. Like we mentioned earlier, the team base. So when we're dealing with one of the cases in our catastrophic groups, I mean, we have 2 or 3 highly competent lawyers on those files the whole time. So to the extent that I'm, pulled away for an operational issue or development issue, I'm really lucky and fortunate that we have as quality of team as we do. Because I'm telling, they're probably better at it than I am. So it's one of those things where I've gotten that level of comfort with so many amazing lawyers that I can step away from the case a little bit and know that when I come back, it's going to be better than when I left it. So, there is in the short term, there's certainly a lot of operational and tech implementations that unfortunately need me to be involved in order for the subject matter to get kind of translated in the right way. But I'm hoping we have a large part of that done over the next year, and that I get to more and more come back to what I really like to do, which is make relationships with referral partners and crush cases.
Yeah, and I think the point you just make is an insight. I mean, it seems so obvious, but it's not until you get really high quality, people that work with you. The higher caliber of people that you can bring on to help work up those cases. The value of it is not even just in what they do on that case. It's reputational. It's the outcomes of the cases. It's the culture within the firm. And going back, Greg and I, there have been times where we hired people probably without the right thought process, really thinking it through, and it didn't work out. It wasn't catastrophic, but then when you do hire people that are of a really high caliber, that, even sometimes do things on cases that are, probably better than what you would have even worked up.
Yep.
I mean, that is just, I mean, I don't think that it can be said enough how valuable that is, probably to anybody, any business, but I think in particular to a law firm's growth and success over time. And again, such a simple insight, but it's so evident when you get the right people there doing that kind of work.
Oh, 100%. I mean, we're one of the points of my highest points of pride is the level of talent and commitment we have on our team. From the front desk to our junior partner. I mean, they're all fantastic. And, it's really a pleasure to work and practice with the people we have on our team. And certainly without that caliber and that quality of talent, we would not be doing the level of production level and that the quality of work that we're doing now.
Well, let's pivot now. I appreciate the little mini master class on how to grow and get to a thriving personal injury law firm. But it is just verdicts after all, and I like to talk a lot about verdicts and trials and so forth. And I know you've tried a lot of cases over the course of your career, but the one that I wanted to talk to you about was the Mazzaros versus, what was it, Southeastern Pennsylvania Transportation Authority case?
Yeah, Mazzaros versus SEPTA. Before we transition, I will say that we are hiring, if anybody's interested.
All right.
Litigation attorneys, litigation paralegals, we're always hiring talent. So before I switch tracks, let me know. But
well, no, but that's good. Well, real quick though, Dan, one other point. What's your geographic area? Obviously, you guys are Pennsylvania, but it looks like you also do work in New York and New Jersey potentially.
So I think we have, last time I counted, we have cases in 25 states. So, we have really, I think COVID, I'd say it's a combination of COVID and the development of our civil rights practice that really taught us that we can take great cases anywhere. So specifically in the civil rights, in the birth injury space, trucking, the larger cases, when you're fortunate enough to get a good one, it shouldn't, to me, it doesn't really matter where it is.
Yeah.
So we have several attorneys that have multiple bar licenses, and we've developed a really nice network of local counsels within the civil rights practice that we now kind of work all different types of cases with. So, while I say that, probably 85% of our cases are in Pennsylvania and 75 are in Philadelphia, thankfully, we do have a pretty diverse practice of that remaining percentage. So we're a lot of places.
And your home office is based in Philly, right?
In Philadelphia, yep.
Gotcha. All right. Well, anybody looking, give Dan a call, and we'll get contact information and so forth at the end of the pod.
Thank you for letting me plug, Brendan.
So pivoting back to just the verdicts, Mazzaros versus is that SEPTA? Is that the Southeastern?
That is SEPTA, yes.
Okay. All right. I always hear that acronym and always wonder what it stood for. Now I know. So tell us a little bit about the Mazzaros case. How does it come in? What's the case look like? And then what are the challenges, if any, leading to this great verdict that you got?
So this is part of our FELA practice that Jim McEldrew built over 30 years, right? It is a unique part of our practice in that we take every case. We take the ankle sprain, we take the amputation, we take the catastrophic injury and the soft tissue, because it is.
Now, why is that? Yeah, that sounds contrary to what you were talking about a moment ago.
It certainly is, and it's unique to our practice, right? In that it is such a relationship-based network that Jim has fostered over the years, that we are, and candidly, it's an opportunity to help a really great group of hardworking people on the railroad within the rubric of the Federal Employer Liability Act, which is a federal statute. So it's an interesting area of the law. It's a great group of people, and given the nature of the relationships, we help everybody. So, and that's what really makes us a resource to the workers on the railroad. So we find that in that capacity, it is an exception to our practice and one that we're committed to. because it really has, it's taken 3 decades to get to where we are in that space. And we hope to extend it going forward with the same model. But the Mazzero's case, was something that kind of jumped off the page from the first day. I mean, Bill was crushed by, and if John was here, he'd be able to tell me the exact poundage, but somewhere under a 6,000-pound spool of wire that pinned him against the interior of a metal container and then ripped across his body, suffering a brachial plexus injury that was really devastating, as well as internal injuries. Great guy, hardworking guy, was new to the job, was placed in a position that was patently unsafe and candidly reckless, within a job that was run unsafely, and his life was changed forever. It was difficult the difficulties would be kind of getting everybody galvanized for trial, right? Getting a real understanding of what a true, real value of the case is. We were putting numbers to SEPTA that they simply don't hear all the time, and we stuck to it, and our client stuck to it, and we were able to I think the client, I'm not going to put the number out, but the client has turned down a significant sum at the very beginning of trial because of the conversations and the way we built the case, right? We built the case to demonstrate both the defense counsel to us and to our client just how serious everything was. And when you looked at the body of our work going into trial, I think it turned out to be correct. And the client showed incredible faith in us, and the number reflected all that combination.
Walk me through. All right, so Bill's a new hire. If this wasn't was this under FELA?
Yes.
Okay. So it's an FELA case, and quickly, for those of us, myself included, that are not haven't worked on FELA cases, can you give us a sort of a framework of what we're dealing with there? I mean, are there any caps on damages, particular issues with respect to how you establish liability, unusual legal defenses that can be raised by the defense?
So it's a carve out to the workers' comp system. So everybody that's listening, I'm sure, has a basic understanding of the workers' comp provisions and what it provides for. FELA specifically was created and carved out, and there's a parallel body of law, the Jones Act, that applies to maritime workers. But the premise was that the nature of the work was so hard, was so injurious. So many people were losing arms, were losing eyes, were losing legs, dying, that they gave them special protections. And this is a 100-year-old federal statute that it provides a hybrid of workers' comp protections with personal injury damages. So that's one of the reasons why we focus on it, because we see it as a really, again, I go back to the quality of people on the railroad. We just had our railroad tailgate, probably 100+ railroaders and their families came out, and they're just great people. And sometimes they really need our help, and we take pride in providing that help for them. So it's an opportunity for us to really have a connection with a specific community, as opposed to, just an isolated referral coming in, and it's unique for us in that capacity. But it does provide an interesting legal framework to practice, where you're going directly against an employer with the full panoply and offering of civil damages. So we build, with the exception of consortium, it doesn't extend to loss of consortium, but we get to build out full damage models for employees that have skilled jobs, making very good money. So it's an interesting dynamic.
Like comp cases, do you still have to prove negligence, or is it simply, again, if the injury happened in the course and scope of work, you're good to go on that?
No, it's not absolute like the comp system, that you do need to prove negligence and causation. So it has the elements of a traditional civil case.
Are punitives available in it if
No
they
punitives
apply?
in the no punitives against the railroad. Nope.
Okay. So So Bill comes to you. He's a new hire. He's working in some type of trained setting, and he's put in essentially a position he shouldn't have been with this dangerous, nearly 6,000 pound spool of reel of copper. So he gets terribly injured, like like you've described. How do you work this case up? And specifically, I understand you guys, and it's interesting to me how much this has changed over the last 10 years. So many firms are utilizing focus groups these days to help work up their cases, sharpen their cases, reframe their cases to get the best outcomes for their clients. And I know you guys are big on that as well. Did you use focus groups? Were there issues that could have been stumbling blocks that focus groups or other aspects of the litigation workup process helped you overcome?
So this was before we really leaned all the way into focus groups. We now have our own internal focus group capabilities where we're initiating a new process at the end of the summer where 1 day a week for the entire firm is blocked off for attorneys to be able to sign up to focus group cases. And that each case is expected to have at least one and in most cases several focus groups over the life of the case. But this was before that period. We did do a big data study, which we still use in certain circumstances, and I think is incredibly valuable.
Can you share who you worked with? Was it Campbell or a different
John and
group?
Alicia Campbell, great people. Happy to give them a shout out. They are phenomenal, best at what they do as far as I can tell, and great people to boot. So they're
Agree.
interested in big data. There's admittedly some difficulties using that in Pennsylvania because of
Can't ask for numbers.
Exactly right. They seem to have a better. I shouldn't say better. They seem to be more useful in jurisdictions where the conversation surrounds, what number you're asking for. But I still see incredible benefit in our backyard in Pennsylvania. But it depends on the case. So we did one of those. I thought it was very helpful. I think that the real issue, liability kind of made itself. We put together a hell of a liability case. Jim McEldrew did the majority of that work. They conceded to liability before trial. So
you're going in and it's essentially admitted liability.
yes. So
That's great.
The real problem was, Bill's a young guy. He's still walking around. For those that know, a brachial plexic nerve injury with CRPS is a non-diagnostic injury. So you're dealing with something that's, you don't have somebody who is, what a lot of people would visually describe as a catastrophically injured person. And the real trick, and I think the credit to the team, because they came up with a great concept, was figuring out how to discuss that seeming discrepancy that we knew the defense was going to lean into, and really address that and own that with the jury. And at the end of the day, our concepts and our strategy worked, and the jury, found in our favor.
Well, let's drill into that a little bit more. So let's start super simplistic. For those listeners who are not super familiar with brachial plexus injuries in particular, or complex regional pain syndrome, CRPS, can you give us a little sense of what those conditions are and how they impacted Bill? Because I'm getting the sense you're saying he doesn't look horribly injured, but this is a very substantial injury. How do we convey that to the jury?
So first, I'm not a doctor. I just play one occasionally. So if I misstate any of this, please don't hold it against me too strictly. But brachial plexus injury is the nerve bundle that innervates from the back of your skull down your upper extremity through your neck. So what happened was when Bill was pinned with I wish I would have brought the animations, because we do have a really neat set of animations that we never got to use at trial. So we will happily give them to your show notes, and to the extent anybody's interested, they can refer to them. But long story short, as this big wheel of wire pulled across his body, it had pinned his arm against his body and effectively ripped and pulled his shoulder, his neck down across his body. So it stretched and in some cases ruptured and tore his nerves that controlled his upper right extremity and went up into the base of his skull down through his neck. So when the manifestations of this was that he was just ravaged. He had pain that was debilitating. He had headaches that were blinding. He had the CRPS went systemic, so it was affecting the rest of his body. He also had digestive from the abdominal trauma. He had, real significant, painful, not for the air implications where his digestive tract was all messed up. He would get extremely bloated. The two things that I think that stood out to me in how we prepared the case were first, really brainstorming with the team to figure out what word choice we were going to use to take the non-diagnostic nature of his injuries and turn it into a value in the case, as opposed to letting the defense use it as an issue against us. So our framework was the structures of a house, the plumbing, the framing, the roof were all sound. So all the structures that you could test with MRI, with X-ray, there's nothing wrong with him. He can walk. He can stand here in front of you. He can sit in a chair, right? But if you look at the electrical wiring within the walls, that wiring has been, stripped, degraded, pulled, ripped to where the operation of the house just doesn't work anymore. And so that was the concept that we used consistently. We leaned into it in voir dire. We took it throughout the entirety of the case. Additionally, we did a lot of work on visuals to try to encapsulate and communicate just the extent of how, I think when you look at medical records, sometimes you lose the significance of what it is to go to a doctor's appointment, right? How invasive it is in your life. And this guy had gone to 1,200 or some odd doctor's appointments over the period of time that he was treating for this case. So we created a big visual calendar and put up a treatment progression that, so when the defense was trying to minimize it, we had this visual that really encapsulated the however many thousand pages of records in one visual snapshot that showed just how intrusive this condition was to his life and how consistently, he was dealing with this, right? When you see somebody going to the doctors, 3 to 5 times a week for 3 years, it's just, nobody makes that up, right? And that's effectively what they were saying, is that our client's up here embellishing and that the damages aren't as significant as what they are. Look, there's no test. So that combination of those two issues, really getting a concept that the jury could grasp onto and creating a quick encapsulated view of the severity of the implications of this treatment on his life, I think really helped us carry the day. And now that it's coming back to me, we also really leaned into, taking their surveillance away from them. They tried to show the stuff he did do, and what we showed was all the dead footage of them sitting outside his house when the shades were drawn, because he was in his laying in his bed the middle of the day on a beautiful day with a debilitating headache and couldn't get out of bed. So we really used what they thought was their best offensive weapons in our own case and leaned into them to take them away, as opposed to let the defense have them.
Well, let me talk about how you did that. So surveillance footage of your client, they're trying to cherry pick sections of it to show to the jury, to frame it as though, hey, this guy's fine, he can do everything normal, just look at him. You are saying, no, wait a second, let's show the whole tape, and that's going to tell a much different story. How did you do that? So you get all the footage from the defense. Did you make the defense show everything? Or did you then say, oh no, let us show you the other part of the video where you weren't shown that, Bill's having to sleep because he's so worn out from his injury and things like that?
I mean, first start with what we do is start not with the video that's produced, but with everything that's not produced, right? In most cases, what you get is some sort of a clipped montage of what the defense wants you to see in the video. So the first thing we start with is we get a tech expert to take a look at the metadata. And to the extent the metadata is not available, we make sure that we get access to it. And then we make sure that we have a complete copy of the entirety of the footage, not the clipped sections that the defense wants to produce. And then potentially more valuable is the documentation behind it. So we, in the beginning of every case, we issue surveillance discovery, for the request for scope of work that the defendant issues in order to get the investigator on the case. All the memos, all the logs, all the bills, all the timesheets. So what we were able to do in this case, and I think was really valuable, was all the non-activity stuff, right? So there would be a list in this log from this surveillance company that would be sitting outside our client's house, waiting for him to do anything from get the mail to try to carry his kid to a car, right? Anything, just monitoring his life for a prolonged period of time. And time again, there was simply no activity. And this lined up with our treating and expert physicians that said Bill was incapacitated in large sections of time due to both CRPS flare-ups and to headaches that were stemmed from the interplay of the brachial nerves up at the base of the spine at the occipital nerve. So, our case already contained the fact that he was isolated because of his injuries, because of his pain. That was the very fact that they were fighting against. And we have their own surveillance people sitting outside of his house documenting that, he didn't come out of his house today. The shades are drawn, no activity. So we didn't really use the stuff that they wanted. We went and really combed through we got probably 500 pages of records from this inspection group. And we used the stuff that they thought was innocuous to prove up our case.
Did you show that in your case in chief, or did you use it on cross-exam with their people having to bolster the surveillance?
I believe we admitted it through the cross-examination of the investigator himself, and then leaned heavy into it in closings. I think that's, if I'm recalling correctly, that's how we did it.
And then there's a distinction generally in federal and state that state, you typically can't get the communications with experts the same way you can in federal. Is this more your ability to get as much background information on the surveillance, the footage, the request for the surveillance to be done, the memos and so forth? Is that a product of it being in federal court, or do you also do that in state court cases?
Oh, this is concurrent jurisdiction. So we're in state court in these cases.
Oh, gotcha.
But the answer is that we proceed against it as if it is a witness, not necessarily an expert witness, right? I don't think that somebody with a video camera has any type of specialized knowledge that requires explanation to the jury. It's more, you and I can go sit out somebody's house and take some pictures. So I see it and address it more as a traditional witness, and we attack the documents as if we're entitled to them, and it works pretty consistently.
Can you walk me through how you used that metaphor of the house and the wiring? From the outside, house looks great, good foundation, nothing wrong with it, but inside, the wiring's torn apart, doesn't work properly, short-circuiting. How did you use that in jury selection? And then I can see how you would use it throughout the course of the trial, but how did you use it in jury selection?
Well, just kind of repeating and addressing the fact that there's differences in types of medical diagnoses, right? There's clinical diagnoses, there's diagnostics, there's differential diagnoses when you compare, when you identify the complaints and kind of lay the potentials next to each other and then eliminate them one by one. And making sure that the jury understood that this didn't need a test because there wasn't one, right? This is a non-diagnostic injury. Will anybody have, ladies and gentlemen of the jury, will anybody have a problem, a problem coming to grips with the fact that there's no test to tell you that there's an injury, but that by the practice of medicine, they come up with what's called a clinical diagnosis, right? So you just start talking about it. Engage with it. And if somebody raises their hand, you get one-on-one voir dire later, talk about it again. And just start inserting the word wire. Start talking about there's no test to determine if Bill Mazeros' wiring is injured. Or his nerves. And you can start start associating the term you're going to use with the medical terminology as early as possible.
Did you work up an earning capacity loss in this case, given the extent of his injury from this?
Oh, for sure. We use a guy out of Texas for a lot of our econ plans in the FELA space, because remember, he's a young man, right? I think he was 34 at the time of his injury, maybe a little younger even. Had a great job, great benefits, good money, hard work, good money. So he really had a job that would have provided for his family, and that's taken away completely. And so making sure that there's a lot of nuances to it, because there is some sort of there's benefits plans for injured workers that you need to understand the nuances of that federal scheme. They also get considerable health benefits and pensions, and so there is a complex economic forecasting model that goes into these cases. It's one of the more complex portions of the case.
Well, out of curiosity on that, are you required under statute to incorporate that? I mean, because wouldn't it be collateral source? Any other, additional benefits that he would have gotten, is that necessarily relevant to decreasing the amount of his, future earnings and income?
Well, it's not it's the RRB, or the Railroad Retirement Board out of Chicago, has a benefit plan that's not dollar for dollar. It does have to be paid back. And the real issue is, what's the loss of earning capacity? So while there might be a set off, the numbers that you're really talking about, specifically in Bill's case, where you're looking at, I mean, there's different where there's retirement structure where, you need to work 30 years on the railroad and be older than 60 to get your full pension. So, I mean, Bill was going to be working on the railroad for another 30 years, right? So there was real money ahead of him, real benefits ahead of him, a pension ahead. So the money that was, laid out between injury and trial was just the tip of the iceberg.
Well, walk me through that. Do you remember? Go ahead, Dan.
Before we go any further, I need to say I did use something that you gave me for this trial.
Oh, do tell.
The man in black suit.
Oh, you used in closing?
Yep.
Good stuff. So
let me go for that. So thank you.
Oh, you're very welcome. I of course got that, ripped that off from several other lawyers that I've heard do that. I will tell you though that this is a complete, offshoot, because I've been thinking about that lately. And I think that there are cases where, the man in the black suit, or the evil man, or whatever we want to call him, that argument model can be very effective. I think the way that I do it, really, there's different ways you can do it. And I think that if you do it the wrong way in the wrong case, it can really backfire. I've done ones where I'm talking about this, giant dump truck full of money, or a giant briefcase full of money. And in the wrong case, I think it's a matter of maybe you're getting out too far in front of yourself. It can turn people off that maybe were kind of, on the fence on which way they were going to find in liability. And I think, we realize now, how jurors think about damages and how they think about overall credibility and the ask and everything can impact the way they look at liability. So it's funny you bring that up, because I love that argument. I love giving it. I love the theater that can go into it. But I've also realized that a more simplified way of walking through it is probably the better option in most cases than the, knock on the door and it's this terrifying guy, and you go into the whole thing with the, the money and so forth. But I'm glad it worked for you, and clearly it did work well in this case.
It did. And, the way that I've dealt with that, every juror almost uniformly, when you talk to them in voir dire about applying damages in Pennsylvania, they're like, how do you do it? What do you mean we have no direction? So, one of the things that we do, teach and consistently do within our trial teams is address that. Like, we are not able to give you a number. However, make no mistake about it, that is your job to determine the amount of money for the harms and losses in this case. And we are able to give you some constructs on how to think about that. So again, we start off early, consistent. I mean, it's talked about throughout the case. So when it gets to that point, and you're right, there's ways to not gild the lily with that presentation, right? Which I think you're talking about, which not getting overly theatric, but framing it in that. Remember that time where I told you we were going to give you a construct with which to consider damages? Well, here it is. And it does, I think, encapsulate in the jury's mind their duty to determine the total loss and harms, right? And which can be difficult, specifically when you're talking about real numbers, right? And give them that obligation that this isn't something that you don't shy away from because it becomes more money than you or I or anybody else has seen, right? You need to take that out of it and really think about what has been taken from this person and fully compensate them for that. So, I do agree that not going over the top is important, but we've seen success with it multiple times now.
So I'll continue because I think that at the core of what we're talking about here, especially in Pennsylvania, where we cannot tell them a number, and especially these days, if you can do a big data study and you can get confirmation on what would be the ideal ask for that particular case, we don't have that. And I think that this argument model is critically important. And I've actually had, I've had cases where I lost and I did it. And I think one, even a juror told Greg they were repulsed by it. But I've had other ones. Oh, yeah. But look, I mean, we were, that's probably a combination of a number of things. They didn't like my case to begin with. I'm on the losing end of the case anyway. They don't like me just because of which side I'm on, that kind of thing.
That's
But I've had
in Erie, I bet.
med mal everywhere. But I've had multiple cases when we got really good verdicts, and literally jurors have said that explanation helped us understand why we do the money. And because I know it works when everything's going right and can help, I do it, but I think about it a lot. And so here's a couple takeaways that I think are helpful and maybe people can apply to their cases. So one, there's that concept of the fair trade value, like you just said, what's been, it's loss aversion, what's been taken rather than what they're going to get. It's not about what they're going to get. And in opening, I'll say, like you said, in closing, we'll talk to you about a way to think about damages and so forth. But in opening, I'll literally say, part of this case, you're going to have to think about what would, in this case, Bill, what would be the fair trade value to him if he had had a choice in this matter? Hey, Bill, all this terrible stuff's going to happen to you. Your life is going to be taken away from you the way that it was. If you had a choice, how much money would you take? I mean, that's essentially the concept. And then in closing, you go into it in more detail. And I think the idea being that, especially in a case like yours where there's admitted liability, it gets a little dicier in comparative fault cases because now, they played a role in it.
Yeah.
When you have admitted liability or an extremely clear liability, I think the big takeaway is the fact that their autonomy and their choice was taken away. And so if they had a choice, how much would they have accepted in exchange for, and then you go through the laundry list of all the different categories of pain and suffering that went through. And then one other one I'll do too is, why. I do why before how. So why, you can give a little constitutional piece on, this is the way that our country came up to do, we're a civil society. We're not barbarians. And so we came up with the idea of, get people from the community and they decide. Okay, it's not perfect, but it's the best, system in the world. Then pivot in. Now, how do you do it? And this is how to think about it. And then you go into whatever the version of the evil man or the dark suit man. And anyway, I digress. You can see that argument's near and dear to me.
I really like that fair trade nuance. I'm going to steal that one too.
Well, I stole that from Rowley, who I'm sure stole that from somebody else at some point in time. So
it's a really great atmosphere to practice in right now.
I'll give you a quick example of how that is so true. I'm a nerd and just super fan of trial lawyers and everything. And obviously, right there at the top these days is Mark Lanier. And many years ago when he got the first, multi-billion-dollar Actos verdict, I think it was like a $9 billion verdict. I had heard that he had a unique way that he presented his punitive damages argument in the case. And, I was a peon. I mean, I'm still a peon, but even more of a peon, 12 years ago or whatever it was. And I just took a shot. I emailed Mark Lanier. I said, hey, man, congratulations on that verdict. That's just unbelievable. Is there any way, if you happen to ever read this, I could get a copy of your, closing argument? And literally 10 minutes later, he writes back, thank you so much. Copies as associate. Please get Brendan the closing and the Actos thing. And I had it like 20 minutes later. And I mean, I still kind of get chills, the fact that he just responded and was so happy to, to send that over. And yeah, you find that, with most great lawyers out there, they're willing to bend over backwards to help people that are interested in getting better.
It's a consistent trait that I'm seeing, and I've definitely been benefited by it. So thank you to everybody I've bothered.
Let me wrap up by just understanding like a few last aspects of the Mazzaros trial and verdict. So, do you remember ballpark what the economic claim was?
Again, I wish John Coyle was here because he would have the precise numbers, but I want to say 2.3.
Okay.
Or somewhere thereabouts.
But the point being, I'm guessing that the vast majority of this verdict, because what was the verdict at the end of the day?
15.65, I think.
So the vast majority of that verdict was non-economics, right?
Yes.
And did you, I mean, to the extent that you're willing to share, since you did an empirical study on it, did the numbers that came from that help you with the settlement position, standing strong because, you had data to show, hey, the range of it is up here and the offer's down here?
Yeah, they never got into 8 figures. I think that had they done that, there would have been a different discussion with the client. So while they put by any objective metric, they put substantial money on the file. They never got to where they really needed to be. I vaguely remember us being pretty consistent with the data in the ultimate verdict. Like it really was, it was a kind of proof of concept for me in that capacity. I think I remember teasing John that we did slightly outproduce them, but not by significant enough to be able to take the weight away from what he provided. But it kind of worked, right? It's one of those epiphany moments where you spend all this time and even a little bit of money working this up, and you wonder, what is this? Is this like the defense attorney just kicks it back at you and says, oh, that doesn't, there's no weight in that, blah, 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 blah. And then when you see it bear out, it really is an impressive thing. So it was one of those epiphany moments for us, and we've been leaning into focus groups and data ever since.
And let me just talk about the way you do. And by the way, I had a very similar experience the first time I worked with John and Alicia on mine. I think I beat their median number by like $150,000 on an 8-figure verdict. And
yeah. I remember that.
I thought I'm a better trial lawyer than this. I thought I was so great. And turns out it's just the information that you have. But in any case, you talked about, you guys are committed now once a month. You're doing focus groups. How are you doing them in-house? Do you have a designated person in the firm that's running them, or are you having the lawyers whose case it is? And where are you getting your people? Are you doing it on Zoom? Tell me a little bit more about that.
The policy is actually getting announced next Monday. So
here's the unofficial teaser announcement.
To the extent that this airs before, surprise, guys. But we do it all Zoom, okay? It's all automated. We've actually reached out and built our own connections to get people. It's run through our operations department. The concept being that if we're finding, I think we've signed, we're on the verge of signing a subscription-based contract to get 2 4-hour groups of 10 people. So once a week for a year. And then there's like going to be a scheduling calendar, and you can take, one section, you can split it up with another lawyer. You can do 2 2s, you can do 2 4s. You can do it at the complaint stage. You can to identify some issues for you. You can do it, middle of discovery to kind of figure out where you need to flush stuff out. You can do it at the end of the case. You can do it all 3. Point being is that, again, with the kind of more back to the central core of the operational focus, when you take away operations, when you cut off pre-litigation and let pre-litigation do their stuff, you really want to give the litigation teams ability to get as deep as they can think about it on the cases. And I think that this, we've been doing a lot more focus groups recently and this spring, and we've had phenomenal success. We're tracking towards our first $100 million year on some pretty big settlements just in the past quarter and a half. So I think in large part due to the value that we're able to extract from the focus groups and the confidence that gives you in your case. I think that truly is where these big settlements come from. The depth of the work, the fact that we demonstrate to the defense that we are not just prepared to argue at mediation, but we're here to go to trial. We'll mediate with you, but we're not doing extra work just for mediation. Here's our trial package. Here's our exhibits. Here's everything that you need to see. This is what we're going to try. Do you want to try it tomorrow? We'll try it tomorrow. And then having confidence that your valuation of the case might be aggressive, right? It's allowed to be aggressive, but that it's accurate. And being aligned with your client in that capacity, having the confidence of the underlying work and not wavering and demonstrating to them that you can either we're going to verdict or you're gonna pay X, Y, or Z. And that has really been another one of those epiphany moments for me personally in my practice over the past 6 months, where I've seen it work time and time and time again. So it all plays into the end result. I think that going back to focus groups, I'm 100% convinced is their value. It's amazing the stuff that you get to see and get to learn and get stuff that you've never thought about. You could have a case for 3 years, think you have it from soup to nuts, and you get it in front of a focus group, and inevitably you're going to take value from it. So it's something that we're leaning into heavily.
Well, and with the list of insane settlements that you've had just here in 2024 so far, it's clearly working for you guys. So congratulations on that. I think that's a good place to call a halt to this great interview. Dan, you shared a ton of really interesting and a lot of food for thought for me. If you'd earlier advertised you're looking to hire for a variety of support positions, but generally speaking, if somebody wants to refer you guys a case, get a hold of you, pick your brain, what's the best way to get a hold of Dan Purtell these days?
My email is just dan@McEldrewPurtell.com. Please shoot me an email. We're hiring for attorneys and staff. We're happy to answer any question that might be generated from this or other information. I really do want to not just take information for others, but actually help people. So to the extent I can help anyone, please just let me know.
Excellent. Thanks, man. Look forward to chatting with you soon.
Yeah, man. Hope to catch up. Thank you again for bringing me on. I really appreciate it. This is great stuff.
Absolutely.
If you enjoy the show, please subscribe to the Just Verdicts podcast on your favorite platform and consider leaving a review. And if you're interested in co-counseling, local counseling, or referring a catastrophic injury case, we'd love to work with you. Call us at 412-281-4100 or visit our attorney referral page at pamedmal.com/refer. Thanks for listening.